Hey guys, welcome back to the channel. In the earlier two videos, we dealt with the top 20 most frequently asked questions about power of attorneys in Singapore. And today we'll discuss another 10. Question number 1. Can a power of attorney be made for medical decisions? No. A power of attorney in Singapore does not cover medical decisions. For medical and healthcare decisions, an advanced medical directive or other healthcare specific legal documents should be used. Question number 2. Can my attorney, under the power of attorney, sell my house if I give them the power? Yes, if you specifically grant your attorney the power to deal with your house in a HDB sale POA or a private property POA, they can sell your property on your behalf. However, you should outline such powers clearly in the power of attorney to avoid any ambiguity. Frequently asked question number 3. Is a power of attorney still valid if the donor becomes bankrupt? Well, if the donor becomes bankrupt, the power of attorney may still remain valid depending on the circumstances. However, the donor's assets and decisions might be subject to the rules of bankruptcy, and the attorney's powers may be restricted. FAQ number 4. Can a power of attorney be used to manage investments? The answer is yes. A power of attorney can grant powers to the attorney to manage the donor's investments, including buying or selling shares, bonds, or other financial instruments. However, the scope of authority should be clearly stated in the document itself. FAQ number 5. What happens if there's a dispute between attorneys acting jointly? If 2 or more attorneys are appointed to act jointly and they cannot agree, their powers may become ineffective. The donor should clearly define how disputes will be resolved or include provisions in case of disagreements. Question number 6. Can an attorney delegate their powers to someone else? Well, generally, an attorney cannot delegate their powers unless the power of attorney specifically allows it by giving the attorney the power to appoint substitute attorneys. This is to ensure that the appointed attorney personally handles the donor's affairs and does not transfer responsibility to another person. Question 7. What safeguards can I put in place to prevent misuse of a power of attorney? Well, safeguards would include the donor specifying the scope of powers clearly in the power of attorney and appointing more than one attorney to act jointly. Question number 8. Can I appoint a company or organization as my attorney? No. Only individuals can be appointed as attorneys in Singapore. You must appoint a person or persons over the age of 21 who are mentally capable to act on your behalf. Question number 9. What should I do if I suspect my attorney is not acting in my best interest? Well, if you believe your attorney is misusing their powers, you can simply revoke your power of attorney. Lastly, can a power of attorney be challenged in court? Yes, of course, a POA can be challenged in the court if there are concerns about its validity, such as if the donor lacked mental capacity at the time it was executed, if the document was forged, or if the attorney is abusing their powers. Family members or interested parties can bring the matter before the court to review and potentially revoke the power of attorney if misuse or other irregularities are found. Thank you for watching, and I'll see you in the next video. Don't forget to like, share, and subscribe.